Bismillah ar-Rahman ar-Rahim, and good evening. Today, once again, we are going to discuss about this 27th Amendment that is recently being passed by the government. And there's a lot of discussion going on for and against of this amendment. So I have a very prominent senior lawyer, Abid Zuberi Saab. He's a former president, Supreme Court Bar Association, and he's a member of Pakistan Bar Council. Thank you very much, Mr. Zuberi, for joining me here. Please kindly tell me that those people who are criticizing this amendment, they're saying that it is a kind of attack on the freedom and independence of the judiciary. The judicial independence is compromised through this new amendment. So what is your view on that?
Bismillah ar-Rahman ar-Rahim. Thank you very much for inviting me. First of all, I must tell you that the amendment, this whole attack started with the 26th Amendment, if you remember. Yeah. In the 26th Amendment, they created a constitutional bench within the Supreme Court. And the Judicial Commission of Pakistan was reconstituted under the Constitution with the bias mostly in favor of the executive. So executive was in a position to appoint judges both in the high courts and the Supreme Court, which are the constitutional courts in Pakistan under the Constitution. And they were able to select judges to be nominated into the constitutional bench. They started with that. But naturally, they experienced, they thought we had to control the Supreme Court totally. And so they always alleged that there was some kind of an agreement between two political parties in 2006, which they called Charter of Democracy, in which both the major parties in Pakistan, Muslim League Noon and which is referred to, and the Pakistan People's Party, agreed that there should be a constitutional court in Pakistan. So they were working in respect of that, and they created this is final combination with the 27th Amendment. They were able to create a court which is superior to the Supreme Court, whose decisions will be binding both on the Supreme Court as well all the courts in Pakistan, which is the Federal Constitutional Court. And they also, when they created this court under the 27th Amendment, the executive got total control for the appointment of judges to this court. So there was no judicial participation or consultation with any judicial member for the appointment of judges to this court. And you have seen that judges have been appointed and the court has started functioning from today. The whole concept of our constitution from the time of the British, even from the Government of India Act of 1935 and subsequent three different constitutions which Pakistan have, culminating in the 1973 constitution, there were three departments of the under the constitution. One was the executive, one was the parliament, and one was the superior judiciary in Pakistan. They were and the concept under our constitution and our jurisprudence is referred to as the separation of powers. All three departments were independent in their field, and they were not allowed to encroach on the functioning of the other. Naturally, there was some overlap, but generally they were not allowed to encroach. Now, by this amendment, what they have done is totally destroyed the Supreme Court. They have finished the Supreme Court as the most senior, highest court in the land. They have created another court for the purpose. All the constitutional cases, all the constitutional petitions will go to this court. Supreme Court has been stripped of its power to decide or hear any constitutional cases. So this is a total fundamental change, and they have basically changed the basic structure of our constitution, because our constitution was based on this trichotomy of power. They have totally destroyed this, and totally made the Supreme Court a redundant court. Only now will be hearing appeals from civil cases and criminal cases. So this is the basic thing, which is that the very fabric of our constitutional law has been destroyed by this amendment. That's why this amendment is being criticized, that that has compromised the independence of judiciary. Number one, why independence of judiciary has been compromised? It is compromised with tenure, security of tenure of judges. Now, petition generally under the constitution starts in the high court.
Sorry to interrupt you, because of course I'm going to put various questions regarding whatever I said in my intro. You said that the judges are not being appointed through a proper, through proper channel. The Supreme Court or the judiciary doesn't have any recommendation or kind of input that used to be for elevating judges to such a level. So this FCC, I mean the Federal Constitutional Court, judges are from where they are coming. They are not a new appointees. They are from either from the Supreme Court or from the high courts. So the judges which are already working in all these superior courts, do you think they don't have a competency to be part of this court?
It's not a matter of competency. It's not a matter of where they are coming from. It's the matter of the way they are being appointed to this court. That's the whole process of appointment is the issue, because one of the fundamental principles of independent judiciary is the concept of appointment of judges. If your appointment judges is being done by executive, naturally the concept of independent judges is compromised. That is a universal principle under any constitutional law in the whole world, under where the constitutions are working. That appointment of judges is the most fundamental part to ensure independence of judiciary. Second is the security of tenure, so that judges can decide cases without any fear or favor. That if they decide some cases against the executive or anybody else, so they will be penalized in some way, which they have done in this case. I will explain to you in when you if you ask that question, or otherwise I'll explain it to myself how the independence of tenure, security of tenure has been compromised. What I was saying, you know that under now when the federal court was established, it is only the prime minister on the recommendation of the prime minister these judges are appointed. Point is that judicial judicial consultation. You see, before originally in the 1973 constitution, it was the judges were appointed by the president, actually on the advice of the prime minister, but with the consultation of the judiciary chief justices. So, but 1996, when the government started appointing judges of its choice without the consultation, proper
So
consultation
there
of the
was a
chief justice,
jihad case or something.
it was not jihad, al jihad,
Al
jihad case,
jihad. Sorry.
al jihad case of
Yeah.
1996, in
Sorry.
which the courts, the Supreme Court at that time in 1996 gave a judgment, a landmark judgment, that the consultation meant meaningful consultation, that you cannot just ignore the advice of the judges, either High Court, if judges was being appointed in the High Court, the Chief Justice of the High Court and the Chief Justice of Pakistan, or if a judge was being appointed in Supreme Court, the advice of the Chief Justice of Pakistan. And after that, you saw judges were appointed in this manner. But then came the 18th Amendment and 19th Amendment, and under that, a judicial commission was established. With at that time, the leaning of the judicial commission was mostly by the judges, and then there was a parliamentary committee, and parliamentary committee basically was made actually redundant. So they basically the judges got their way in appointment of judges. Then a lot of criticism came, and I think fairly so. Okay, but first of all, under the one of the judgments of the Supreme Court, a lot of judges who had taken vote under the Provisional Constitutional Order (PCO) of General Musharraf were sent home, packing home. That had seen some very good judges. We lost some very good judges at that time. Then again, then after all, then but this bias. So now they have totally reversed the whole process. And now under the 26th Amendment, the Judicial Commission was reconstituted. Now the balance again shifted totally in favor of the executive, and judiciary was basically sidelined, and all the recommendation of the superior, including the Chief Justice of Pakistan, the senior judges, were totally ignored, and they appointed their judges. They appointed judges to the Constitutional Court. Now with the setting up of this Federal Constitutional Court, that even the requirement has been done away with. Now, subsequently, when this court has been totally constituted, in future, when the judges are going to be appointed to the Federal Constitutional Court, they will go to the Judicial Commission of Pakistan. Again, executive is dominant there. Now, what most important thing that for 75 years of this country, in the jurisprudence of the country, the decision of the Supreme Court, of earlier Federal Court, and then the Supreme Court was binding on all of the courts. Now, all that jurisprudence has been done away with, and it has been stated that the Federal Constitutional Court will not be bound by any decision of the Supreme Court. That means all that jurisprudence in Pakistan for the last has been done away with. Now they can decide whatever they want, irrespective if we can cite some judges, the Supreme Court in a full court of 17 judges decide this, it is not binding us because Constitution has removed that thing from us. We can decide according to our own manner. So the doctrine of precedent has been done away with. In the Article 189, which says the order of the Supreme Court was binding on the other courts, has been done away with. Now the Federal Court is the superior court. Its decision will be binding on the Supreme Court and all other courts in Pakistan. So these are the very fundamental changes. They have changed the very basic structure. And there were judgments of the Supreme Court that no amendment could be made. Because the Constitution is made by a constituted body. Their function is to make the Constitution. Once the Constitution amendments can be made to it by the Parliament, and Parliament, there were some other provisions were added by General Ziaul Haq at that time. They could amend anything under the sun, and that amendment will not be questioned in any court of law. That irrespective of that, the Supreme Court had decided cases saying that irrespective of this 239 clauses 5 and 6
The
was there, the
judicial review
Constitution.
was there. The judicial review.
Judicial reviews there. They said that constitutional amendments could still be challenged if you could able to prove that the the basic structure or salient features of the constitution. For example, we are Pakistan under the constitution is Islamic Republic of Pakistan. If you say Parliament has not can to pass any law, tomorrow they can remove that clause from the constitution. Say Pakistan will not from tomorrow. Pakistan will not be. Can the Parliament do that? No, because it will be against the basic structure of.
So you're right. You're right, because there is a
So
lot
they
of.
basically what they have done away with the court. The Supreme Court is now no longer the superior court of the country, the highest court of the land, with the power judicial. And judicial reviews also be controlled. Now in the High Court, Sindh High Court has a constitutional bench. Only one High Court. Only those judges selected by the Judicial Commission, which they executive has power, are appointed in that bench. All now with this under 27th Amendment, all petitions under Article 199, which gives the power judicial review to the High Court, has been given to this constitutional bench. And 2 days ago, an ordinance was passed by the Sindh Assembly saying that if any judge refuses to sit in this constitutional bench as constituted by the Judicial Commission of Pakistan, he will stand retired. If a judge refuses to go to the federal court,
but I think they have the retirement section has been reviewed. It is the Supreme Judicial Council which has to decide about.
No. Supreme Judicial Councils will remove a judge for misconduct, etc. That is the concept. That's the purpose of Article 209 under the Constitution, which gives judicial. But here, if the judge refuses to go to a court, which they say he stands retired, you see, there he will be removed for misconduct or whatever thing. Here, he'll be deemed to have retired. So that's a different concept. Here you would see, for example, now High Court, how further they have controlled the High Court. How they control the High Court? Earlier, in Ziaul Haq's time, the judges could be transferred from one court to the other court. Now, in India, there's a different system. Always people give example, India, this is happening in India, and this country is happening. Our jurisprudence is very particular to our country. In our country's jurisprudence, a judge post Ziaul Haq's era, the clause was amended, and it said that no judge could be transferred from his own High Court to another High Court without his consent. Now, this consent part has been removed. And now, if the judge refuses to go to a different, he stands retired. Everything is now retired.
Do you think, Mr. Zuberi, that there is a problem of transferring the judges to other places within the jurisdiction of Pakistan? Because then there are, so many other institutions which the officers are being transferred frequently from one place to another, from one province to another, and they do function. So do you think there is a problem into it?
Please kindly don't compare a civil service or district judiciary with the superior judiciary of Pakistan. District judiciary, when you enter district judiciary, you are of a province. A district judiciary functions all over the place, and you can be transferred from, for example, you are in Karachi, you can be transferred to Hyderabad, Sakkar, Mitti, or any other place, like in Punjab or other place. Civil servant, when you join a civil service in all Pakistan civil service, you can be posted anywhere. The Supreme Judiciary is not, because the posting and transfer is. High Court also has benches. For example, one day I'm working in Karachi, the Chief Justice can send me to Sakkar where the bench is, or Hyderabad or something. That is done.
No, my question, you are right. My question is, what is the problem in it? What is the harm going from one province to another province? Do you think that the entire function of judiciary changes from one province to another, or the whole law changes?
No, the law doesn't change. Naturally, a person. I remember Pakistan also has experienced this thing. When Pakistan became one unit, if you remember, Pakistan was one unit. East Pakistan was one province, and West Pakistan was province. And the West Pakistan used to be West Pakistan High Court with benches at Peshawar, Karachi, Quetta, and Karachi, Quetta with it was in Karachi and Lahore. So it has functioned like that. But issue is that once you are appointed to a judge in a province, you don't want, for example, if I don't want to go to Lahore, it is not incumbent on me. I will be shifted to Lahore. But as a punishment, you see, for example, today I'm a judge of the Sindh High Court, and I concur with the Chief Justice before the 27th Amendment. If they said if you want to become judge of the Islamabad High Court, you see, mostly the provinces, judges in Islamabad High Court came from the provinces. So that was okay. But for example, today I'm working as a judge of the Sindh High Court. Suddenly I'm saying go to Balochistan, and as a punishment, for example, those judges who decide cases, this removal will act as a punishment. Yes, if for example, before a judge could be
So
transferred,
do you think that this will force the judges to not to decide with the
against the
what you
executive,
call it? Yeah,
the exact judicial review,
keeping in
judicial review.
mind the justice system
Yes,
and the law
for example.
in front of them.
Yeah, because because if I am fearful that if I decide a case against the executive, suddenly I'll be transferred, and if I don't get transferred, and if I don't agree to that transfer, I'll stand retired. Suddenly I'll think about it before deciding that case against the executive. Basically, what they have done is they have controlled the decision-making power of the judiciary. Now they don't want any case to be decided against them. They want whatever they say, because the petitions which we file against is against the executive
So,
for
okay,
judicial
okay.
review of their
Now
actions.
let us come back. Not let us come to whatever narrative or whatever the arguments that you have presented in this, especially this question regarding the independence of the judiciary. What has convinced these political parties? This is a hypothetical question. That what have convinced these political parties, the ruling parties, to bring such a drastic changes in the judicial structure of the country because of the past actions of the Supreme Court or the high courts of Pakistan against these political parties. That may be one of the reasons, like Iftikhar Chaudhry and Saqib Nisar and people like other, judges which decided political cases in favor of one political party, victimizing the another one.
If you decide a case victimizing somebody, that is not allowed. That's not on. That's not justice. Because you have to do justice between. But political cases do come there. Don't you think in the federal constitutional court, political cases will come between parties? For example, if they decide tomorrow to ban PTI, first it used to be under the law, under Article 17 of the Constitution, you have to get that verified, or rather upheld by that decision of yours for declaring a political party as banning a political party by the Supreme Court. Now they have given that power to the federal court, where they have appointed their own judges. So now, I know first of all, we may say some action against one political party, and they may be banned, maybe. Then you will see action against
So
certain judges of this.
you suggest that it is a malafide kind of a
Yes, bilkul.
amendment
I say this,
with.
bilkul, this amendment is totally modified by political. Dekhiye, I will not defend the judicial overreach which the Supreme Court did. I totally agree. Okay, that judicial, and Justice Mansoor Shah, who stands retired now, he has left the Supreme Court because his conscience didn't allow to continue. He has given judgments that judiciary should not indulge in judicial overreach. Once you judicially overreach, say, if you start interfering in all the executive
But we
actions, then
remember, we remember Zuberi Saab when, Iftikhar Chaudhry along with other judges were restored by the two political parties in 2009. I
nine.
remember, yes, because they decided in election 2008 that once we come into the power, we will restore the entire judiciary. It was done. Then we have seen that regularly the section 184(3) was being applied on everything in this country. Even the civil bureaucracy was left stand still, not to operate. So do you think that this is the job of the senior most judges of a country?
No, absolutely not. That was not the job of the day, to paralyze the functioning of the government. Absolutely not. There are two, three decisions given by the Supreme Court were really questionable, like the Rekodik judgment and the Steedman judgment. I'm sure you remember that.
Yeah.
But that does not justify the wrapping up of the, or doing up of the Supreme Court of Pakistan. You could have amended it. You could have issued amendment to to stop this kind of interference, but to remove it totally, to remove the Supreme Court as the most highest court of the land with constitutional powers, that is not on. That does not mean if you disagree with something, or you think that was wrong in the past, because what is happening, the biggest loss is to the people of Pakistan when they will file writ petition challenging any decision of the government. The government will come and say, you are if you pass any judgment against me, you will be interfering in my working. I have passed an
But
order. I
but
have a right to
but
pass
I
any
think
order.
that but I think that these constitutional cases, mostly they are among the state institutions or province of the federal government or some,
No, sorry.
you know,
No, they are not. With utmost respect, they are not. The Supreme Court used to have, now the federal court has original jurisdiction of dispute between any provinces. There's Article 1, it used to be Article 184(1). We are talking about 184(3), which gave the power of the court to decide these suo moto and other periods. That was, as you say, that was abused by the superior judiciary. Article 184(1) dealt with the provincial dispute between two provinces or
okay.
federal government of the provinces. Something that was original jurisdiction was with the Supreme Court. Still, that vested, now it is vested with the under 175E with the federal court. So that is something else. We are talking about the action taken, but mostly petitions are filed under Article 199 or 184(3) as used to be, because 184(3) is no longer, they are part of the Constitution. It used to be between people like me or you coming to courts and saying that my fundamental rights on a question of public importance has been affected by any government action. Please give me relief. That was the question. They were saying, because it started with a good intention. If you remember, bricklanes were very downtrodden people of our society. The bricklanes, especially in Punjab,
Yeah,
there's a lot of
yeah.
bricklanes. So in 1990, Supreme Court decided the first time, the main first issue with public interest litigation was regarding that. And Supreme Court gave a judgment in respect of that. That was very welcome. But now then interfering in each and everything, there are certain good decisions with that. The dispute came when you thought the Supreme Court was deciding cases in favor of political party, but they forgot that this PDM government came into existence because Supreme Court of Pakistan, Chief Justice at that time, Mr. Justice Bandial, gave a judgment in favor of Noon and People's Party and ensured that no confidence was passed against Imran Khan, and the restoration of assembly by or dissolution
So
of the assembly
my
was set
my
aside.
question is for the viewers: do you think that the previous structure of the judiciary, the previous structure of the judiciary, was such that which gave massive powers to the Chief Justice of Pakistan as well as the Superior Court judges to decide cases against a particular political party or a particular political leader, which led to where we are standing today, bringing, this 26th Amendment and then this 27th Amendment. And I don't know, the government may have a, idea of bringing 28th Amendment as well, but
Yes.
I have no idea. But it is because of the past conduct of the judges that brought, this executive uh, and the judiciary head-on kind of a situation.
Yes, I think to a great extent you are right in that. But you see, if a political party approaches a court, that it is now suffering from state oppression, and that the Supreme Court, because in our politics, you have seen in the past when there were only two parties. When one party came to power, People's Party came, it started vendetta against Muslim League or other parties. And when Muslim League came in power, they started vendetta against Shahid Benazir. You have seen that, and you have seen that how judgments were also procured from the High Court against Shahid Mohtarma and President Asif Zardari. This is part of our history. So you are
History, yeah.
right. So yes. But point is that again there was political interference and judges were aligned with them, those judges, and they had to pay the price. They had to resign, if you remember. They had to leave the judiciary because of what they have, and there are certain judges who had to go under the Supreme Judicial Council. But you see, if I'm a political party and I'm suffering state oppression, or you and me are, where will I go for relief? I'll go to the Supreme Court or the higher court. And if that court decides in my favor and says that yes, you are, the state action against you is unlawful, unconstitutional, that means that the government will say, okay, oh, the Supreme Court has decided against, they should be wrapped up. Then what happens to the judicial review? Then do away with the judicial review. Say that no state person will be able to file a case against the government or its excesses. That will be the end of the. But until you have this judicial review, the power of judicial review, the superior courts, that will be excised. And sometimes it goes against you. That does not mean that what is the court saying? Court is only saying what you are doing is unconstitutional. And if your High Court used to say you could appeal against the Supreme Court, then Supreme Court, they said there was no further appeal. It was a review. But Supreme Court is the final court of appeal. And if you lose there, they can American judiciary. We say the American president was the most powerful person on earth. But when his decision, when the Supreme Court decides against it, He does not wrap up the Supreme Court. He just says, I'm bound. You are bound. This this
Okay,
opinions of the Supreme.
okay. Your point is quickly one question. You know, from public perspective, from the perspective of the people, you know, there are. It is said that hundreds of thousands of cases are pending in the various courts throughout Pakistan. Who is responsible for this? Is it the lawyers who are pleading or defending the cases, or the judges? Uh, I mean, the executive, who is responsible for this? Whatever kind of judiciary you have in this country, at the end of the day, it is the common man, the common person who is going to suffer. Who is responsible?
You,
The
first
judges
of
or the
all,
lawyers or the executive?
I think everybody is responsible. Everybody has his part in
But this
the
is a
failure of
vague
the
answer.
system.
I'm sorry to say,
The point
because
is,
we are not fixing a responsibility on somebody. We have to fix
no,
a responsibility on somebody.
I'm saying that we are all responsible, but some are more responsible than the others. The most important aspect is that most majority of cases are pending in our district judiciary. There's
Okay.
nothing done in this country to reform that. It is the need of the hour to reform our judicial system in the lower judiciary, even the high courts, and then the Supreme. Because not every case comes to the Supreme Court. Used to come to the Supreme Court. It was only a very limited number of cases used to come to the Supreme Court. There was pendency, but does not. You cannot force justice delayed is justice denied. There's one saying, and
Mm.
justice harried is justice buried. If you harry the justice, you can quickly you have to decide, then you will bury the justice. The main issue should be justice. You just have to implement the system. You
Do you
have to
think, as a
improve the system.
lawyer practicing for so many decades, that in Pakistan the people do get the justice?
They do get. Well, I'm saying because you don't never hear of those
Eventually,
cases
after
of justice.
decades and decades.
No, sometimes not in every case.
Yeah.
You are right, because civil cases takes time. Because most important aspect in these cases is lack of judges, appointment of judges. You see, judges are pay who pays these judges? The executive. So the judges, until you appoint more judges, you come and see most of the judges. A lot of judges places are empty in our district judiciary. The judges are not being appointed. It takes time for their appointment because they have to be paid by the from the exchequer by the government. So if government is eventually responsible for this, then amendments have to be the most important is that high court. But now there are two aspects. One is civil jurisdiction, one is criminal jurisdiction. Broadly, under which we are different jurisdiction, and you have the constitutional jurisdiction. So civil jurisdiction, it takes time. Constitutional jurisdiction did not used to take that much time, because you and I also go and file cases, petitions against government excesses. But you and I have a property dispute or any other civil dispute, we'll go to to the district judiciary and file our civil suit. It takes time because it requires evidence, and then there's appellate procedure
Okay.
provided
So
in that.
very sub. I'm short of time. Just last question and a short answer. That where we are moving from here, where we are standing, where we are talking at the moment, that the structure of the judiciary, according to you, is naturally it has been shaken. It has been shaken in a very bad manner. Where we are moving? Do you think any political movement against this CN by the government, lawyers, or the political parties, or it will happen the same way? It would be treated like the 26th Amendment in this country.
I think lawyers have to unite. First of all, lawyers are not united because the lawyers group which controls the bar association, mostly Supreme Court bar, Pakistan bar, they are allied with the government. So you won't expect any Supreme Court bar or Pakistan bar. They have already
So
supported
it
the
means that
27th
there
Amendment.
are majority of the lawyers who are
No,
supporting this
sorry,
27th Amendment.
with utmost respect, majority of lawyers are neither lawyers of the Supreme Court. Majority of lawyers are lawyers who are lawyers of district courts or high courts. They do not take part in
But
the election to the.
99% judges are sitting wherever they are sitting. Either they are being, sent to the FCC, or they are in the Supreme
No,
Court, or they are in
they,
the High Courts. They are there. They haven't.
no,
Only three judges so far has resigned, and they have
first of all, I
opposed to
have
this
my personal,
27th.
I have my personal view that they should not have resigned, but naturally their conscience did not allow their personal decision to resign. They should have remained within the system, and because they could have decided cases, even if they are there, they should have remained. But naturally their conscience did not allow, because they thought that they took oath under defend the constitution, and they were unable to do it. Hence they chose the respectable path, and they resigned. But the issue is that the basic structure of the constitution as we knew is finished. until this amendment is reversed. Whether there's a movement or not with the state oppression, we have seen in the last 2 years how that will be perceived. It all depends on how we have in Sindh, the lawyers are united. The Sindh Bar Council, there was a big convention against the 27th Amendment in Sakkar. So Sindh lawyers are very active. Now let's see what happens in Punjab and other places. But Sindh is totally against. So Sindh Bar Council has passed a resolution. The High Court bars have passed the resolution. So Sindh is also against that. Inshallah, because we have a vested interest to defend the constitution of Pakistan. You will see that lawyers will be united. Majority of the lawyers, certain people who benefit. In the times of Ziaul Haq and martial law times, there were lawyers who were always with the powers to be. But there were people they were not successful. They even gave their lives. But eventually, the system came back, and the rule of law was restored. This amendment has taken away the rule of law, and this society which does not have rule of law cannot sustain itself.
Appreciated your time, your views. Thank you very much, Abid Zuberi Saab,
Thank you for inviting me.
former President, Supreme Court Bar Association, and a member of Pakistan Bar Council, senior advocate. Thank you very much for your precious time.
Thank you for inviting me. Thank you. Assalamu alaikum.